Who actually gets blamed when a tree branch crashes down on your car during a storm? You would think Mother Nature takes the fall, but the law does not care about weather. It cares about who owned or controlled that tree. If the tree lives on public land, like along a sidewalk or street, the city or county usually holds responsibility for keeping it trimmed and safe. Think of it like a landlord who never shows up to fix the leaky faucet, except the faucet is a 5,000-pound oak branch. Private property flips the script completely, because now the homeowner or business owner is on the hook. If a tree in your neighbor's yard rots for 2 years and finally topples onto your fence, that is not an act of God. That is an act of negligence. Negligence just means someone knew, or should have known, something was dangerous and did nothing about it. Picture a tree with a giant crack down the middle for months, ignored like a check engine light nobody wants to deal with. Here's where things get spicy, because government entities often get special legal protection called sovereign immunity. That basically means you cannot sue the city the same easy way you would sue your neighbor. There are strict deadlines and notice requirements involved. Some cities require you to file a formal notice of claim within as little as 60 days after the incident. Miss that window and your case can get tossed faster than a game show contestant who buzzed in too early. Now let's talk shared responsibility, because trees do not respect property lines like polite dinner guests. If roots or branches cross from a private yard into a public sidewalk, both parties can end up sharing the blame pie. Insurance companies love to play hot potato in these cases, each one pointing fingers at the other. That is exactly why documentation matters, because photos and weather reports become your best friends in a dispute. Weather actually plays a huge role in how courts decide these cases. A tree falling during a completely calm, sunny day looks very different from one falling during a Category 3 hurricane. If the tree was already visibly dead, cracked, or leaning, courts often say the storm was not really the cause. The real cause was somebody's failure to notice the obvious warning signs, kind of like ignoring smoke just because you cannot see the actual fire yet. Tenants add another twist to this leafy legal drama. If you rent your home and a tree on the property injures you, the landlord may still be responsible depending on lease terms and local laws. HOAs get dragged into this too, since many neighborhoods have rules about tree maintenance written into their governing documents. If the HOA promised to maintain common area trees and dropped the ball, they can share in the liability. Proving your case usually comes down to a few key ingredients: evidence of prior complaints, inspection records, and expert arborist opinions. An arborist is basically a tree doctor, and their testimony can turn a shaky case into a slam dunk. The biggest lesson here is boring but true. Document everything and act fast. Waiting too long can cost you your entire claim, no matter how obvious the tree's problems were. So next time a branch crashes down and you are left staring at the damage wondering who pays for it, remember it usually comes down to ownership, notice, and timing. If you want to learn more about how we help people navigate cases like this, check out our links in the description.